It's 2:35 a.m. on September 10th, 2021. In my effort to appeal to the federal district court what I understand to be an unlawful proceeding under the guise of an eviction proceeding, I cited in the affidavit that I attempted to turn in on the day of the unlawful proceeding, which was September 3rd, 2021, the Texas Rules of Civil Procedure, sections 1, 2, 8, 9, 11, and 16, regarding certain pleas to be verified. But I also cited Texas Rules Civil Procedure 306C regarding prematurely filed documents um, in connection with consideration of Rule 526 regarding sworn pleadings. Why? Because my understanding was that the unlawful proceeding was itself an attempt to create a transactional moment intended to deliver on significant acts of fraud that had occurred in the course of me being denied due process. And that in the course of me being denied due process, this eviction proceeding was serving to try to elicit a bond on my faith and credit that was supposed to deposit to somebody else as if it was some sort of execution of a lien against me and my property, which also included intangible property associated with my efforts at due process, which have been repeatedly and spitefully denied to me, specifically in Dallas for the last 2 years, but also in the state of Texas altogether for more than 4 years. I also submitted a list of evidence when I submitted to the court, the federal district court, on September 7th. I also submitted a list of evidence that cited federal rules of evidence, Rule 803, hearsay exceptions, availability of declarant immaterial. Under Rule 803, 1 says, present sense impression, a statement describing or explaining an event or condition made while the declarant was perceiving the event or condition or immediately thereafter. The reason I submitted that specifically is because in the denial of due process, I have been keeping a record. I've also been providing public notice insofar as I have access on transactional events that are not only part of the fraud scheme, but that are also connected to efforts to try to intimidate me as well as threaten me. And that the denial of due process, while these other things have been going on correlatively, as I have said, is evidentiary. Part of the evidence is also my sense impression of what's being done, including if I'm being subjected to harassment, including if I'm being electronically tortured. Understand, please, I have received professional technical training in techniques that can, if abused, be used to electronically torture somebody. I didn't seek out to learn this, but in the course of what I was seeking out to learn, I do have cognizance that such things are possible. The fact that my technical training, which was intended for something else, but may well have actually been disabused and defrauded out of me so somebody else could steal my identity and use the certificates of my technical training to engage people in acts of electronic torture, is part of the allegations of securities fraud. And securities fraud is a serious charge, and I understand that. For instance, so this is why these sense impressions are important. It goes to state of mind. And state of mind goes to culpability, including intent. And so, insofar as I am consistently subjected to abuses of the actual official, literal judicial process that don't make any literal sense, except insofar as what they're trying to do is intentionally impact my state of mind. And part of that goes to a refusal to acknowledge that I was kidnapped as retaliation for trying to report child abuse and fraud that was happening at a domestic violence shelter, engaged in acts of electronic and other torture of women and children, including threats that the children were going to be removed from their custody unless they acquired mind altering substances in the form of controlled substances that are actually scheduled as controlled substances under the law via intercession with the medical sector by getting their child diagnosed as having a mental disability so that then they could be prescribed medication. And in the course of that, their children were being subjected to experimentation regarding a number of products that were never disclosed to their parents and consent for which were never acquired. And I know because I've been tracking that. And it happened to me, and it's happened to me for a long time. So when 12:30 comes along and the door opens, and the person who I understand is the subject here comes in the middle of the night, this is disturbing to me. I'm disturbed. I'm also disturbed because I was sleeping, and in the course of sleeping, I woke up and understood somebody was underwriting something on an electronic account somewhere, threatening my life. And so we're in a situation where my understanding is that what is happening is people that are identifying themselves as being officers of the law, including judicial officers, including judges, including people alleging themselves to be clerks of the court or magistrate judges, and people that are members of a bar society but refuse to adhere to the most basic standards of appropriate conduct considered to be qualified as professional conduct expected of them in their positions, while I am completely denied any recourse to anybody that alleges they're qualified to practice law, including a prosecutor, including some sort of defense attorney, including somebody alleging themselves to be a magistrate judge, or even a judge. And I've only been in court twice, and they've been at alleged eviction proceedings. But what I've seen is that the actual judge in the proceeding has the capacity to assure that who they're talking to understands what's happening. They will even ask if that person's aware of certain laws and ask that person to say, okay, what do you understand this law to be? So what is it that when I get to present before the judge, every single time, the reaction I'm met with is what my first sense impression tells me is an effort to subject me to an intentionally orchestrated act of sadism. Sadism is a real thing. It also speaks to state of mind in regards to who I'm talking to. If you already know and present yourself as being a professional, including a professional with a certain kind of bonding, including a professional identified as having a position within a governmental organization, which a court of law is, and I ask for permission to speak candidly, and then the first thing that's done is it's dismissed, while something is associated with the case before that would otherwise seem irrelevant unless it's actually what I accused of happening in the court, which was an act of intentionally orchestrated securities fraud. Now that turned out to pan out. If you actually acknowledge the charges are accurate, but no one acknowledges the charges. What I keep getting is more and more accruing acts of securities fraud, things that are masquerading as if they are legal documents on the record as the official decision and also the official work products of the people whose names are on those documents, replacing, substituting, or attempting to cover up for the fact that the actual merits of the case have not been considered at all. And what is revealed over and over again is a process whereby the manner in which the response is effectuated is intended to subject me to increased duress, including duress associated with material poverty. And now it has been escalated that material poverty not only involves throwing me out on the street with absolutely no just cause, when there's actually, according to the public records accessible, the complete antithesis of what was allowed to be presented in court during the acquisition of a judgment in an unlawful proceeding. But there is now also something that doesn't make sense, which is a levying of a fine or a filing fee and a threat of a dismissal with prejudice if I do not make the filing fee within a period of time that is of shorter duration then what is being used as the basis for me being denied my claim as in need of proceeding in the form of a pauper? Why? Because I've been denied income the whole time. And I've been willfully and intentionally denied income. Why? Under the law, there's no legal justification. But the responses I've received, including now from 3 named federal district judges, including from 2 named magistrate judges, do not even literally respond to the actual charges presented in the case. And there's no referral, for instance, to a prosecutor for consideration. And even the invocation of the allegations that it's not the appropriate jurisdiction do not hold because they do not respond even to the specific information in the motion itself establishing the jurisdiction. They invoke some other jurisdictional consideration that was not presented in my motion, but turns out at some point in time to be relevant in some other motion. It is not constitutional to completely deny an American citizen her rights to due process so she can merely be exploited for somebody else's efforts to proceed under the law. There's nothing constitutional about that. And anybody that aids and abets it, my state of mind says, has willingly committed themselves to a criminal conspiracy, including a conspiracy that allows for the representation that they are committing these acts in the role of a federal district judge, a federal magistrate judge, a judge in a justice court, a clerk of the court in justice court, a clerk of the court in federal district court, a clerk of the court in the Supreme Court of Texas, even a justice of the Supreme Court of Texas. Every single time they allow their name to be put on something that is a material falsehood, it is, in fact, by the letter of the law, a form of fraud that qualifies as securities fraud. Why? Because, as I've cited in a previous motion, specifically the role of the clerk of the court. And even if I am compelled to request waiving of filing fees or court costs because I've been intentionally denied any income, including income that would be paid to me if I were acknowledged as a legal professional, so that I would be compensated for the legal work I've provided in composing the motions, doing the legal research, making arguments, including insofar as I presented them before the court that I already know other people have read and used as part of their legal efforts. Even if that there is still a surety of some sort, and this is the essence here. If I'm denied due process, and I'm also consistently subjected to efforts to coerce me, including in manners that I understand effectuate a form of mental duress that legally constitutes torture, and yet I'm not given any other recourse, then what are they using as the surety on the proceeding that allows them to get credit as having provided work, that they wrote the judgment, that they wrote the findings and conclusions and statement of case, that they wrote the order? You see, that would be work that would be credited to them, that presumably they've performed in their job. Did they not get paid? And if they did get paid, who paid for it? Because what's happened is the work they're getting credited as doing is not responding to the actual case. And so every single time they put their name and their faith and credit and the faith and credit of the court on that document that contains a material falsehood, it is an act of securities fraud. Every time. And it becomes more and more compounded when, in an effort to try to seek legal redress, it ends up resulting in what has happened recently. right? And I cannot relent on this insofar as I understand that it literally got to the point that after they cleaned me out for the last 2 years without responding anything at all, literally, to what I actually requested consideration of, including me as a professional, I had no choice but to appeal an effort to put me on the street for completely false charges under completely false pretenses. And the way that they've responded, it's sadistic. You don't get paid to be a sadist. You don't get to say you're representing the people so that you can engage in acts of ritual torture. That's my state of mind right now. This is some sort of elaborate, completely unconstitutional ritual of torture of a specific kind of woman that fits a specific kind of demographic. Why? In the state of Texas, there is no privileging of a sect. It doesn't say specifically religious sect. Is that sect the State Bar of Texas? Is that sect the Federal Bar Association? Is that sect the American Bar Association? Because it's consistent insofar as I'm left with absolutely no recourse in any way, shape, or form except to go back to the same system that is monopolized by members of a specific exclusive society that do not follow the rules that they say they are held to and will not even provide me with the kind of protection I would need from somebody who is a member of that society. My understanding is that insofar as these judges and these magistrate judges, as well as these clerks of the court, have been able to be compensated in their job for doing what their signature on the documentation in all of these cases says they've done, then what they've said is they've also read my filings. They've read my petitions. They've read my appeals. That means they've read my legal efforts for over 3 years. At least for over 2 years in the federal district court here in the Northern District of Texas. And if they didn't read them, then they created acts of securities fraud in a materially false document of the case that tried to deny my rights to due process by putting on the record a prevention of me from being able to move forward in my case because of the manners in which they presented their order or their judgment or their finding. I lack jurisdiction. I'm engaging in bad faith. That it would be futile. They put on the record. They read my work. You cannot say you haven't read me. So why would I not be considered read into law enough to be accorded enough professional consideration that you would consider and understand it is a libel against you as a professional to allow yourself to be represented within your own milieu as having committed to these kinds of acts of securities fraud? If I've done something in error, including procedurally, or something about my filing may call into question some aspect of my integrity as a professional, you already have a process by which to reconcile that internally. Why then would you allow yourself to consistently be put into a position where other people you're associated with are also libeled insofar as they would accept your judgment as credible in consideration of the performance of their job, including a job at an equivocal level or a job at a superior level?